Hi, welcome back to Finally Revealed. In this episode, I want to talk to you about what happens if someone dies and they didn't have a will. In some other videos, I talk about wills and trusts and also transferring or making arrangements to transfer property or to have property jointly held so that it automatically passes. Sometimes people are going to take advantage of those transfers on property or joint property situations so that it doesn't really matter if they have a will, because all of their property is taken care of when they die. However, there are people who don't have a will and don't take advantage of transfers of property in advance. And so what happens? Well, what happens it is that in order to transfer property from the name of a person who's now dead to a live person, you're going to have to go to the court, and there are different kinds of proceedings that can be filed depending upon how much property they owned when they died, and also what kind of property. If it's real property or personal property, but you're going to have to go to court to have the court determine who the descendants of the person who died. And the first thing that they will look at is if that person was married. So it kind of goes in a picture. It goes out to the side first. So is the person married? Then if the person is married, that person is their primary heir when there's no will. And if there is no spouse, do they have children? So you go sideways, then you go down. Are there children of this person, and are they of legal age? If they're not of legal age, then there will have to be someone appointed to take for the children. But if they're of legal age, the children would be the heirs. If there is no spouse and no children, then you go up to the parents. Did the person who died have parents? If there are no parents, then you go again sideways. Are there any brothers or sisters? And then you would go up again to grandparents, and then over to aunts and uncles, and down to cousins. And so that's how the determination of descent is made, and the court makes it. So there's certain information that would have to be filed in order for that to occur. If a person dies and they don't own any real estate, and they don't have anything in a safety deposit box that you'd have to get into, they don't have any big investments that didn't name someone as a beneficiary, and they just have a small amount of personal property, maybe they're a tenant, they have some deposits or things on file, but everything else is rather small, you might be able to get away with just not filing anything. To be official, you're supposed to do that, but not everyone does. But if you have to get into a safety deposit box, if you have to inquire about assets, if you have to inquire about final paychecks, if you have to inquire about transfers of property, and if this person died owning real estate, you definitely need to file probate, because that's the only way that property can be transferred. It's always best for the person who dies make arrangements in advance. Another thing, what if you are out of town, you live in a different city than the person who died lives? It can make it more complicated as you go. And filing the action, you're going to have to advance the funds before you can get the assets gathered into the court in order to get paid back. So it can be an expensive proposition if there are significant assets. So talk with your family and talk with your friends and encourage them to make the arrangements in advance. It will save everyone from possible headaches. I hope this was helpful to you. If it was, leave a comment below. If you know someone who's saying, I'm not going to mess with talking about my property, when I'm dead, I don't care, maybe you want to share this with them. It might give them some suggestions. It's sometimes people can't face the fact that they're going to die, but it's a little bit better to be prepared, or a lot better. We love subscribers. Please click the red button, and I'll see you next time.